Morning, Officer Barstow. How are you?
Hey, good morning. Can you hear me?
Yep.
Okay,
We're just
good.
trying to connect to New Haven, so hopefully it'll happen eventually. There we go.
Hey, good morning. Sorry,
Good morning.
we had a rough morning.
No worries. I'm glad you made it.
I'm happy that we're right on time.
Completely on time. Can we please start with Mr. Sterns?
Okay, so here's the thing is that since we're on no movement at this point, I only have 2 of the 4 guys for you. So I have
Okay.
Mrs. Zacharino and Marrero. Sterns, I haven't even had a chance to get him ready yet.
Okay, that's fine. I need to just locate Mr. Zacharino's attorney, so I guess you can put Marrero in first, please.
Okay, Marrero, come on in, buddy.
Yep.
No problem. And then Zacharino will be next?
Yeah, as long I just have to find his attorney as long as she's here.
Sure.
Right, so let's grab your stuff, Mr. Morero. Send an email. I think they're watching. Great. So good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Phillip Morero, inmate number 451067. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
My name is Phillip Morero, 451067.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. So this is a preliminary hearing, which has 3 purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. And you should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. The hearing today is being recorded, and the testimony at today's hearing will be taken under oath. So, Mr. Morero, can you please raise your right hand? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you do have rights for today's hearing, and the first rights you have is the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney can represent you at today's hearing?
Yes, I filled out all the paperwork so I could be represented by a public defender, but I can't get a hold of a notary to make it valid. I have everything filled out right here in front of me.
Okay, I've
sent 3 requests already, trying to get a notary to have this notarized, and I haven't been able to.
Okay, so just to confirm, Mr. Marrero, you are seeking counsel for this hearing?
Yeah.
Okay, so what we're going to do then is I'm going to continue today's hearing to my next hearing date, and that will give us time. We'll put a request into the public defender's office to get in touch with you as well.
Can I just say something?
Yeah, absolutely.
Because, yes, my sister was trying to
Hold on,
get
is
a
this
hold of.
towards the charges though? Is this towards the
Yes,
charges?
yes, because I'm here innocently.
I
I'm here
don't want you to
innocently.
speak about them because you do have pending charges in court. So I don't want you to make comments to incriminate yourself because anything you say here
No,
can be
no,
used
well,
against you.
okay, yes. Well, I want to say something. My sister has been to the victims unit, whatever they call that, victims. And she said that she didn't want to put no charges. Nobody wants to put no charges. I didn't do anything. I didn't do
Okay.
anything wrong.
Okay.
I
Okay.
mean,
And
she went to everybody. She went to the victims unit. She went to the prosecutor's office. She went to the public defender's office. She went to everybody trying to tell them that this is all a mistake, that I'm here innocently.
yeah. So the thing is whatever happens with court and in court has to take care of that. And with the pending charges here, that's just what we're looking at. So it's in your best interest to keep doing her outreach there. But for today, for Paroles purposes, if you're seeking counsel, we will continue this hearing. That way the public defender's office can get in touch with you to review the case.
Well, when will I be able to get this notarized? Unless I get this notarized, they say this is not valid for them to represent me. I can't get a notary.
We're going to reach out to their office as well, and maybe they can schedule a legal call with you to go over that information with you. So just because you can't get a notary doesn't mean that you can't utilize their services. So, well, like I said, we can
do. Can I submit this without a notary? It says it right here.
That it needs to be notarized.
Is that our application? Can I chime in? Is that our application for our
Absolutely.
services?
Yes.
You don't need to have it notarized, sir. You can just mail that in to us.
Oh, okay. Do I have
Okay,
to
it
put a
does say
stamp?
notarized, but we will take an unnotarized application from you. So I'm going to chime out now. You should mail that in if you want a public defender.
Okay. Do I have to put a stamp that says legal mail, interdepartmental mail?
No stamp is needed, sir.
Okay. All right.
Okay, so
Give it to your counselor. He or she will know what to do with it.
I'm sorry. I can't even hear. What did you say?
Give it to your counselor. It will go into departmental mail without a stamp.
Okay.
Okay, sir. And we'll be more than happy to take your application, okay?
Thank you.
And as soon as we get it, we'll get in touch with you.
Thank you so much.
Thank you,
You're
Attorney Jamagletti. So, and we will also reach out to their office as well to let them know you're requesting representation, okay? So as of right now,
I keep saying I'm innocent of all charges. If anyone would just take the time and responsibility to speak to my sister, they will see that I'm innocent. I'm in prison for doing nothing.
Yeah.
Yeah,
it's hard because you have a lot of aspects to it now too. That is something that needs to be handled at the courthouse and at the court level with that stuff going on. So
they have me scheduled for tomorrow, but without transport. What does that mean?
Yeah, I don't know.
No transport.
Yeah, I'm not sure. So
I can't hear you. What?
Oh, yeah, it is breaking up. Like I said, we do not unfortunately have anything to do with the court or the court proceedings at this point.
I mean, how long do I have to stay in prison innocent? It wouldn't hurt so much if I wasn't innocent.
Yeah, I can't give you that answer because it is a pending court proceeding. So that, like I said, doesn't have anything to do with parole at this point. We're working on the violation, but you still have that pending in court. So I think it's best if
why shouldn't someone take the initiative to at least speak to my sister? I mean, this is all part of it.
Sir,
Part of a complaint that's supposed to be lodged.
Yeah.
Sir, if I can just interject. You have court tomorrow? You have court tomorrow?
Yeah.
Have your sister go to...
They have me under no transport.
Sir, okay. Have your sister go to court tomorrow.
Okay.
She can talk to the prosecutor. Sir?
This is just what she's got to do.
Sir, this should just be a quick continuance for counsel. And I don't want you to keep saying anything because you're going to hurt your case. So just the hearing examiner is giving you excellent advice. Mm-hmm. So what she's going to do, I believe, is continue your case. Tomorrow, have your sister go to the courthouse and give a statement. Okay?
Okay.
Thank you.
See, I didn't know this. I didn't know this.
Sure.
Thank you.
Okay, now
It's
you do.
okay, Mr.
Thank
So
you.
Ms. Marrero, we're gonna conclude today's hearing with you. I am gonna continue it to my next hearing date, which is April 17th. Mail that, give that to your counselor immediately so they can send it to the public defender's office. I'm also gonna note that you
Okay.
are requesting representation. So we'll do our due diligence to also send them information that's needed. And we'll see you
Okay.
back again on the 17th of April, okay?
Thank you very much, and I'm
All right,
sorry if
you're all
I
set.
did something wrong. All
It's,
right.
I get it, you got a lot going on, but unfortunately, there are steps and there's separate situations going on. So go, I'll see you in about a week or so, on the 17th, and we'll work on getting you that counsel, okay?
Thank you so much.
All right, take care, Mr. Marrero. I'll see you in a little
Okay, thank
bit.
you.
All right,
Thank
take
you
care.
very
This
much.
does conclude today's
Thank you.
preliminary hearing for Phillip Morero. Thank you, counsel.
Thank you. Thank you.
Just right now, not every day, just right now. So give me a few minutes and I got you.
Sorry, you have Zacharino? Yes.
I do, yes. Can you come in?
He's good
Okay.
to come.
Perfect, come on. And then I have your other two guys getting ready now.
Great, so after Zacharino, then we'll jump to Sterns, please.
Sure.
Thank you. Good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Michael Zaccarino, inmate number 365116. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Michael Zacharino, 365-1116.
This is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Attorney Hannah Dean on behalf of Mr. Zacharino. Good morning.
Good morning.
So this is a preliminary hearing, which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates the condition of your parole. The second is to determine, if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you see at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Zacharino, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning the case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Great. So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. And at the conclusion of the hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
So you do have important rights at today's hearing, and I'm going to review them with you now. You have the right to an attorney, and representation is present here for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you also have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do.
Okay, so we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So in charge number 1, condition of GPS, the charging officer reported that on 2/20/25, you were placed on GPS due to your instant offense of burglary first. The GPS agreement was reviewed with you and you were instructed to submit to GPS monitoring and comply with monitoring requirements. You then signed the agreement indicating that you were aware of the instructions and monitoring requirements and you failed to abide by agreement number 5 and 11. Charge number 2, condition of curfew. On the following dates and timeframes, you violated your GPS curfew, 3/10/25, 9:04 p.m. to 9:50 p.m., 3/11/25 from 9:04 p.m. to 9:52 p.m., 3/12/25 from 9:04 p.m. to 10:16 p.m., and 3/18/25 at 3:31 a.m. to 6 o'clock a.m. You violated GPS agreements number 11. I will remain in my approved residence between the following hours of 9 p.m. to 6 a.m. and you signed the agreement on 2/20/25. On charge number 3, condition of drug testing, the charging officer reported that on 3/19/25, you were instructed to submit to a urinalysis supervised by P.O. Schmidt. You stated that you could not render. You were then instructed to submit to a neat oral fluid swab. You stated that your mouth was too dry. Before a search of your person, you admitted to having altered urine in the bottle and with the intent to prevent parole from obtaining your biological urine sample. On charge number 4, condition of program participation, the charging officer reported that on 2/20/25, you were provided with a flyer for MCCA and instructed to have scheduled or completed an intake appointment by your next reporting date of 3/6/25. On 3/6/25, you failed to have scheduled or completed an intake appointment with MCCA as instructed. You were issued and signed a misconduct. In charge number 5, condition of residence, the charging officer reported that on 3/18/25, you were unsuccessfully discharged from Evergreen Sober House with your parole, your parole approved residence. The discharge was due to your failure to comply with the Sober House rules, engaging in outpatient treatment at MCCA, drug use on 3/14/25, and drug overdose on 3/17/25. On charge number 6, condition of drugs, the charging officer reported that on 3/19/25, you admitted to your supervising officer that you relapsed and used crack on 3/14/25. You signed a voluntary admission on 3/19/25. You admitted to your supervising officer that you used crack on 3/17/25. Overdose and Narcan was administered. For your conditions, you are not used or have in your possession or control any illegal drugs, narcotics, or paraphernalia. In addition, the state has filed the following exhibits that I'm going to note before I start reading is that I did not receive Exhibit J, so that's not going to be taken into consideration. And in addition, I separated Exhibit F and G, and I will state what they are. So I have Exhibit A, the Connecticut Conditions of Parole. Exhibit B, the Connecticut Board of Parole Remand to Custody Order. Exhibit C, the Notice of Parole Violation / Parolee Rights. Exhibit D, the Parole Violation Report. Exhibit E, the Decision Information Summary / Revocation Summary. Exhibit F, I'm identifying as a GPS agreement. Exhibit G, I'm only identifying as the offender misconduct. Exhibit H, the voluntary admission / picture, altered urine specimen and Yale hospital admission wristband. Exhibit I, the Evergreen Sober House discharge email. Again, Exhibit J, the New Haven PD report I did not receive. Exhibit K, the violation description and position history, and Exhibit L, the signed MCCA flyer. So counsel, did you and your client receive the parole violation report, the parole violation notice, and all the other documents that have been identified besides Exhibit J?
Yes.
Okay, great. So I have not received any exhibits or evidence from the defense. Do you need time to submit any evidence at this point?
No, thank you.
And we do not have any witnesses. So it is the state, it is now the defense's opportunity to respond and make a short statement, calling witnesses and testify with respect to probable cause and the severity of the allegations.
Yes, thank you very much. As to the first charge, GPS, I would just argue for this one that the charge does not indicate the date and time in which my client allegedly violated the agreement numbers 5 and 11. So I would argue that charge, the standard has not been met, as the burden is on the state to establish the time, dates, and necessary information for these charges. As to charge 2 curfew, I would argue that the alleged violations on 310 and 311 are minimal. The violation that is alleged for 318 was the date that my client did experience the overdose, was seen at Yale New Haven Hospital, and he was there after told he was not able to remain at the sober house due to that. So I would argue that that specific incident on 318 was not an intentional curfew violation for him. Charge 3, drug testing. I would argue that the PC standard has not been met for this charge either, as my client was already incarcerated on 319, as is indicated by the remand, and no evidence has been submitted to show that he was supposed to render urinalysis on that date. The state does have the burden, therefore I would argue PC has not been established on that charge. No comments as to charge 4. As to charge 5, I would just note that this was due to my client overdosing while residing there. This was a situation where he just failed to, return to the sober house or anything of that nature. It was a situation where he did unfortunately overdose and then was kicked out. As to charge 6, drugs, I would argue that the evidence does not match the allegations. Specifically, the alleged misconduct was not signed on 319 as my client was incarcerated at that point, and no other evidence has been submitted as to that charge. So I would argue that the probable cause standard has not been established. And then lastly, I would just argue, should you find that these allegations do arise to the levels of probable cause, I would just argue that this isn't serious enough to warrant revocation for my client. Importantly, I want to note his max date is in May of this year, May 14th, and he clearly needs to establish services while in the community, specifically treatment to better himself and contain his sobriety, maintain that once he gets out. So I would argue that providing him the assistance of parole to get back on his feet, establish services in the community would be extremely beneficial. So I would argue to have him released as this is not serious enough to warrant revocation. Thank you very much.
Thank you. Okay, so I'm just gonna take a moment and I'll announce my findings. So for charge number 1, the condition of GPS, I'm making a no finding of probable cause. Based on the information reviewed during the preliminary hearing, as counsel stated, there's not enough information to prove the violation occurred. On charge number 2, I am going to make a partial finding. So I guess I'll separate it into 4 parts, 1, 2, 3, 4. So part 1 through 3, I'm making a finding that he did violate the condition of curfew based on exhibits A, D, F, and K. On part number 4, dated the 3/18, counsel testified that her client was in the hospital due to overdose, so I'm making a no finding. Sorry, I'm just gonna write my notes as I'm going. On charge number 3, condition of drug testing, I'm making a no finding of probable cause. Again, the state failed to submit sufficient evidence in support of the charge, and the elements were not met because of that. On charge number 4, the condition of program participation, I am making a finding of probable cause based on state's exhibits A, D, G, and L. On charge number 5, condition of residence, I'm making a no finding. Again, I believe that the state failed to submit sufficient evidence in support of the charge and did not meet the elements. And charge number 6. I'm gonna make a partial finding. Okay, can I just confirm? So you're saying that he signed the voluntary acknowledgement for his use on 3/14 on the 19th, you said?
So that was exhibit, let's pull it up. Yes, so it's exhibit H. So the actual date that exhibit was signed was 3/18. But they state in the PBR that it was signed 3/18, and then it was for use on a different date.
Okay, got it. So they signed it 3/18, but the PBR says.
The PBR states that it was signed on 3/19 as to using on 3/14. It was signed on 3/18, and then there was nothing submitted as to the admission on 3/19. There were no signed admissions submitted for that one.
Okay, all right. So for charge number 6, I am gonna make a finding on the drugs. condition based on states exhibits A, D, and H, because H is signed on 318. So those are my findings, and with that, I'm also making a finding that the acts are serious enough to warrant a revocation. And that I've also determined that you're gonna remain incarcerated while you wait for your revocation hearing. So the office, the records office of the facility will be notified of this, and your office and the community will be as well. I did note that your end of sentence is before the 60-day regulation needed. So if you don't have your hearing before, then you'll just EOS, okay?
All right, no problem. Thank you very much.
Any questions right now,
That
Mr.
is it.
Zacharino? All right,
That is
take
it.
care then. Good luck. So this does conclude the preliminary hearing for Michael Zacharino, inmate number 365116.
Thank you.
Thank you, sir.
Thank you.
Thank you. I'll see you in a bit.
Later.
Are you taking on Sterns or Walker next?
Sterns.
Thank you.
Yep. Just to Mr. Officer Barstow, you're still with us?
Yep, still here.
Awesome, great. Okay, so good morning. I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Garrett Sterns, inmate number 334640. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and New Haven Correctional Center. Can you please state your full name and DOC inmate number for the record?
Certainly, Garrett Sterns. My number is 334640.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti and Parole Officer Barstow. Attorney Famiglietti, can you please identify yourself for the record?
Sure. Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, everyone.
Morning. And Officer Barstow, can you please identify yourself for the record?
Yep, sure. Good morning, Officer Barstow, Special Management Unit, New Haven Parole and Bridgeport Parole.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is a better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Sterns and Officer Barstow, can you both please raise your right hands? Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you.
I do.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I will then review and identify exhibits filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, the state will have the opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
I do not.
So you do have important rights at today's hearing, and I'm going to review them with you now. You have the right to be represented by an attorney at this hearing, and counsel is here present for you. You also have the right to receive a written notice of the charges of violation. Did you receive that written notice?
I did.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence as part of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do, and I am.
So we're going to review the charges now that the state, your parole officer, is bringing against you, and the information underlying each charge. So Officer Barstow, can you please read the charges you have brought against Mr. Sterns?
Yes, charge number 1, under obey all laws, obedience to the law. On September 18th, 2024, you were served with an outstanding warrant out of Torrington Police Department, case number 24-25934, and charged with the following: harassment in the 2nd degree, Connecticut General Statute 53A 183A2, and threatening 2nd degree, Connecticut General Statute 53A-62. According to reviewed documents, on August 5th, 2024, at approximately 10:56 a.m., you sent several threatening text messages via cell phone to a known third party. Charge number 2, general no contact. On August 5th, 2024, at approximately 10:56 a.m., you made contact via cell phone to Tina Shaw. This is a direct violation of your BOPP stipulated condition of throughout your period of parole, you are to have no contact with Tina Shaw.
Thank you. The state also has filed the following exhibits that they've pre-marked for identification purposes. Officer Barstow, can you please identify the exhibits you submitted?
Yes, Exhibit A, remand to custody. Exhibit B, parole agreement. Exhibit C, the Torrington Police Report, case number 24-25934. Exhibit D, misconduct report dated August 9th, 2024. Exhibit E is the notice of parole violation, and Exhibit F, the parole violation report.
Thank you. And you also submitted an addendum on March 4th, 2025. That's also being admitted into evidence. Can you please read the addendum submitted?
Could you read it? My case notes is acting up right now.
Absolutely. Yeah. Offender has been sentenced to 6 months under docket L18W CR 24-0189655S for threatening second physical threats. To the same docket, the charge of harassment second, tell or other communication resulted in a nolle prosequi. Got nothing. Offender is currently incarcerated at New Haven Correctional Center with an EOS date of 3/25/2025. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have. And just for the record, that disposition happened on 2/28/25.
2/28/25. Thank you.
You're welcome.
And then in addition, I have received the defense's exhibits. I have Exhibit 1, the list of parole accomplishments and future plans for parole reinstatement. Counsel, do you and your client need any time to submit any additional evidence?
We do not.
Okay, so today we do not have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. So Officer Barstow, would you like to make comments towards the charges?
No, I'm all set.
And counsel, it is now your opportunity to call any witnesses, present evidence, and speak to the charges.
As a result of the plea and conviction, we have no comment as to the preponderance standard.
Thank you. And then just take a moment and then I'll let you know my findings. All right, so for charge number 1, the condition of obedience to the law, I am making a finding based on your conviction of threatening second when you received a sentence of 6 months in jail. In addition, the evidence that supports the charge is exhibits B, C, and F. For charge number 2, I also found that you violated the condition of general no contact based on the evidence provided in support of the charge, which is states exhibits B, C, D, and F. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. And once the state is finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine the outcome I will recommend. So Officer Barstow, would you like to make any comments towards Mr. Sterns' history, background, any of that?
No, thank you.
Okay. And counsel, it is now your opportunity.
Thank you. Good morning. My client accepted responsibility for his conduct. I received 6-month sentence. That sentence is now over. I believe the PO recommended jail until the charges were disposed. Correct me if I'm wrong. The charges have been disposed of. He has served the sentence. It's misdemeanor conduct. There were messages sent via text. This was an impulsive act, an emotional act. I believe he's learned his lesson. He's sat now for over 6 months. He's single. He's 39 years of age. His support comes from his mother, brother, grandfather, both his maternal and paternal uncles. He has a 7-year-old daughter who lives out of state. He has his high school diploma from New Milford High School. At the time of remand, he was searching for work. He has last employment at Daily Moving and Storage back in October of 2020. He participated in the Explore program while incarcerated. He's been waiting. He's on the waiting list for a detail job. He would like to be placed in a halfway house in the Waterbury area. And in the future, he would like to enroll in a counseling program, and he aspires to become a counselor and to give back. He'd like to successfully complete the Explore program, and he'd also like to enroll in individual psychotherapy. I don't think this crime or this allegation of violation is significantly serious enough to require further incarceration. There is no physical violence. There are no injuries. This is his first violation of parole. I understand that this occurred the first day. However, he has been supervised and punished in jail now for over 6 months. I think he's ready, willing, and able to reintegrate back into society, and I don't think any further punishment is necessary. Thank you for your time and consideration.
Thank you.
You're welcome.
Any final comments before I make my recommendation? Officer Barstow, any additional?
No,
Sounds
no,
good.
thank you.
For me to go forward, counsel, I can move forward.
Yes, I have no further comments. Thank you very much.
Thank you. So I have listened to the testimony today, and I did review all the evidence presented. Based on that, I am going to recommend Mr. Sterns, your parole be revoked and you serve an approximate 9-month period of confinement. That's with a re-parole date of May 19th, 2025. In addition, I'm going to recommend the following conditions: no alcoholic beverages, behavioral management program for DV, no contact with victims BM, JV, and TC, a general no contact with TS. No operation of a motor vehicle without parole officer's permission, problem with sexual behavior treatment, and I do see half a house placement in Waterbury, correct?
Yes, that's
Yeah.
correct.
Got it. Okay, so those are my recommendations. They are going to go to the board on April 17th, 2025. After that date, you'll get their decision shortly after. They can do a few things at that date. They can lessen my recommended sanction. They can adopt it, or if they want to choose to go longer, they will call a supplemental hearing, which you'll be present for to address their concerns, and they will give you a different date then. So that is my recommendation. Do you have any questions at this point, Mr. Sterns?
I do not, thank you.
Okay, sir, just give us a call on the 18th of April. Call our office, and we'll be able to tell you what the board decided. Okay, sir?
Okay, thank you very much.
You're welcome.
This
Have a good
concludes
day.
the
Thank you,
revocation
everyone.
hearing for Garrett Sterns, inmate number 334640. All right, thank you, Mr. Sterns. Good luck to you. Thank you, Officer Barstow. Thank you, Attorney Famiglietti. I will see you soon.
Thank you. Have a great day.
All right, everybody have a great day.
Bye-bye.
You could come on in, board. So unfortunately, this ain't gonna break into school. Try to lower volumes. That'd be helpful. Oh, and the one next door? Yeah. I'll give it a shot. Give me 1 second. Okay. Give me 1 second. Go ahead, give me a second. Can you hear us though? I think you should be good. If you need me, I'm ready.
Officer Trusello, you're muted.
Oh, thanks, Kristen.
But we can.
I can
so
hear
we can
everybody.
you.
Can you hear me now?
Yeah.
Okay, good.
Yeah.
Yeah, all right, good. Officer Barton, are you with us?
Yes, I am here.
Awesome. All right, let me just grab your attorney and we will get started. Okay, so good morning. I am Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Sylvester Walker, inmate number 130938. Today is Monday, April 7th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office, the New Haven Correctional Center. Can you please say your full name and DOC inmate number for the record?
My name is Sylvester Walker, 130938.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica and Parole Officer Bartnick. Attorney Sirica, can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Walker.
Thank you. And Officer Bartnick, can you please identify yourself for the record?
Yes, Parole Officer Bartnick, Waterbury District Office.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Walker and Officer Bartnick, can you both please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. Perfect. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present any relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. So we're going to go over your rights for today's hearing. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes. Yes.
Do you have the, okay, great. So you have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, so we are now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So Officer Bartnick, can you please review the charges that you have brought against Mr. Walker?
Yes, so as it relates to release directions, charge number 1, GPS. You failed to charge your GPS unit for a minimum of 2 hours per day, which resulted in the GPS shutdown on the following dates and times. On 1/6/2025 at 11:20 p.m., your GPS unit shut down until approximately 1/7/2025 at 9:39 a.m. On 1/9/2025 at 7:30 a.m., your GPS unit shut down until approximately 1/9 at 8:23 a.m. On 1/12/2025 at 12:26, your GPS unit shut down until approximately 1/12/2025 at 1:34 p.m. On 1/12/2025 at 8:31 p.m., your GPS unit shut down until approximately 1/12/2025 at 9:07 p.m. On 1/18/2025 at 5:27 a.m., your GPS unit shut down until approximately 1/18/2025 at 8:48 a.m. On 1/20/2025 2025 at 7:51 a.m. Your GPS unit shut down until approximately 1:20, 2025 at 9:11 a.m. On 1/24, 2025 at 8:41 p.m. Your GPS unit shut down until approximately 1/24, 2025 at 11:54 p.m. On charge 2 of curfew, on 1/8/2025, you failed to abide by your scheduled curfew of 9 p.m. to 6 a.m. On 1/8/2025 at 9:35 p.m., you left your approved residence, did not return to your residence until 1/9/2025 at 1:35 a.m. On 1/9/2025 a.m., on 1/9/2025, you failed to abide by your scheduled curfew of 9 p.m. to 6 a.m. On 1/9/2025 at 9:35 p.m., you left your approved residence and did not return to your residence until 1/10/2025 at 12:29 a.m. On obey all laws, charge number 3, obedience to the law. On 2/3/2025, you were observed by Waterbury Police Officer Bailu loitering within the hallways of a structure located at 453 West Main Street, Waterbury, Connecticut. As Officer Bailu entered the structure, you attempted to leave the building and avoid police contact, but were subsequently stopped outside the rear deck of the building. At this time, you reported to Officer Bailu that you did not reside in the building. Subsequently, you were arrested by the Waterbury Police and charged with criminal trespass in the 3rd degree, and also 2 counts of Connecticut General Statute 21A-278B, possession of narcotics with intent to distribute. On 2/4/2025, you were arraigned in Waterbury Superior Court under docket U04W-CR25-0512988-S, probable cause of found arraignment. Under charge 4, under drugs, on 2/3/2025, while you were being arrested by Waterbury Police for the criminal trespassing 3rd degree, you were also found in the possession of narcotics, which subsequently led to your criminal charge of 2 counts of Connecticut General Statute 21A-278B, possession of narcotics with intent to distribute.
Thank you. You have also submitted exhibits that you've marked for identification purposes. Can you please identify the exhibits you submitted?
Yes. Exhibit A, signed special parole conditions. Exhibit B, remand to actual custody order. Exhibit C, parole violation report. Exhibit D, notice of parole violation, parolee rights. Exhibit E, decision informational summary. Exhibit F, Waterbury Police report. Exhibit G, GPS monitoring agreement. Exhibit H, Allied Universal Monitoring reports. Exhibit I, offender misconduct report for 1/14/2025. Exhibit J, offender misconduct report 1/27/2025. And Exhibit K, CT judicial case detail docket U04W-CR25-0512988-S.
Thank you. And then you did submit an addendum on March 17th. That's also admitted as evidence. Can you please read the addendum you submitted?
Yes. On 3/14/2025, you appeared in Waterbury Superior Court, GA-4, under docket U04W-CR25-0512988-S. You were found guilty of Connecticut General Statute 53A-109, criminal trespass in the 3rd degree, and were sentenced to 30 days in jail. The 2 counts of Connecticut General Statute 21A-278B, possession of narcotics with intent to distribute, were nollied.
Thank you. Counsel, did you and your client receive the notice of parole violation, the parole violation for, and all the other documents that have been identified for today's purposes?
Yes, we did.
Great. I also received Exhibit 1 from the defense, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need any time to submit additional evidence?
No.
So today we do not have any witnesses. So at this time, it is the state's opportunity to call any witnesses, present evidence, and speak to the evidence submitted. So Officer Gardner, would you like to make a statement towards the charges?
I do not at this time.
And counsel, it is now your opportunity.
Yes, I have a few questions. Good morning, P.O. Bartnick.
Good morning.
A couple of preliminary questions. How long have you been supervising Mr. Walker for?
For approximately about a month and a half.
Month and a half. Okay. So is it fair to say, according to the documents I've received here, my client, it appears, was paroled on December 1st of 2022. You obviously, based on your testimony, you were not supervising him at that time, correct?
That is correct.
Okay. Were you aware of when Mr. Walker was put on GPS?
I understand, I can look at the date, yes, but yeah.
Right, so was he previously on GPS prior to you taking over supervision?
Yes, he was.
He was, okay. So, Mr. Walker, this is a question for you. Do you recall when your GPS monitoring started upon your being re-paroled on December 1st of 2022? Do you remember when you were put on GPS?
Yes. Before then, I was put on GPS because I was on regular parole on GPS also.
Okay, so when you got
I've been on
re-paroled on December
GPS since 2019.
Okay, but on your you were paroled on December 1st of 2022. When you got re-paroled, on that date, you had a GPS unit on your?
Yes.
On your,
Yes.
Okay. So, and obviously, P.O. Bartnick was not your parole officer at that time, correct?
No. No.
Okay, and according to the documents here, I'm not disputing these GPS shutdowns, P.O. Bartnick. Mr. Walker, is it fair to say from December 1st of 2022 until January 6th of 2025, there were no issues with the GPS unit, correct?
Right.
Okay, you didn't have any other remands, you didn't get written up or anything of that nature from December 1st of 2022 to January 6th of 2025, correct?
Right.
Okay.
Right. Correct.
Okay, so at some point, Mr. Walker, when you had, it looks like January 6th, January 9th, January 12th, there was a couple, January 18th, January 20th of 25, and January 24th. Was there any issues either with the charger or with the unit?
Well, I did have issues with the charger charging it.
Okay.
And I was told to get rid of it and use another one. And I had at least 4 of them, and 2 of them didn't charge the unit anymore. So,
Okay.
But I did find one that did charge the unit.
Okay, who did you have that discussion with regarding the issue with the unit? Was it P.O. Bartnick? Was it someone at the halfway house?
I believe before P.O. Bartnick and P.O. Bartnick.
Okay. And at some point, either the actual unit or the charger, do you recall what was replaced, if either one or both or neither?
I replaced the charger.
From whom?
I had several of them.
Okay.
I had 2 that I was using every day. It seemed to didn't work anymore. I mean, the light would come on, then I would catch the light off, you know what I'm saying? I thought it might have been due to my electricity at the house, but it had to do with the charger.
Okay. All right. But, all right. So once again, from December 1st of 2022 to January 6th of 2025, there's no issues with, you were on GPS, so it's no issues at that time, correct?
No issues.
Okay.
No.
All right. P.O. Bartnick, question for you regarding the curfew from January 8th of 2025 and January 9th of 2025. It appears both of those curfew violations occurred at the same time at 9:35 p.m. Did you have any discussion with Mr. Walker as to what was going on at 9:35 p.m. for either of those violations, or any communication with Mr. Walker?
Yeah, from my understanding, we did speak, and based on the GPS coordinates, like I said, from my knowledge, he was observed at a restaurant/bar around those times.
For January 8th of 2025 at 9:35 p.m. He didn't return to 1:35 a.m. at 9:25 and 9:25. Once again, he left at 9:35 p.m. and did not return until 12:29 a.m. on 1:10:25. You had some discussions with Mr. Walker regarding those 2 curfew violations?
Yes, as he did sign a misconduct for those violations.
Okay. Mr. Walker, do you recall those 2 curfew violations and having a discussion with P.O. Bartnick regarding those 2 dates?
Yeah, but I told him I was at work.
And where were you working at?
I was working part-time around the corner for Sam's auto tire shop. And that was on several occasions around that same time. He would call me up and tell me we had to empty the truck, load the tires, or we had to load the truck, load the tires. I notified him, told him I was working part-time there. And I also notified my previous, parole officer about that. And I was under the impression that my, curfew was 11:30, not 9:30, because the whole time I would come in at 11:30, it was no problem. You know what I'm saying? But I did leave those times and go out to my job at the tire shop to unload tires or load tires. And that's what I remember telling Officer Barton.
And you left, according to the documents submitted by P.O. Bartnick, both violations, your curfew violations occurred at exactly the same time, and you left,
Right.
allegedly left at 9:35 p.m., correct?
Right.
Okay.
Right.
Right. Regarding charge number 3, I do agree the addendum that P.O. Bartnick put on the record. That is my information. I have also, my client was not initially charged with some narcotics charges. Those 2 charges were not lead. He did plead out to a criminal trespass, and that is correct. He did receive 30 days to serve on that violation. And that's all I have for the first part of the hearing. I do want to be heard about his background at the appropriate time.
Thank you.
Now, I do want to just add also, although I wasn't supervising the offender back in 2022 or 2023, I did include the misconducts for when he was supervised by me, but there were also GPS violations and misconducts written in 2022 and 2023. Just want to add that.
Thank you. So I'll just take a moment and I'll let you know my findings. On charge number 1, Mr. Walker, I am finding that you violated the condition of GPS based on the evidence presented in exhibits A, C, G, H, I, and J. On charge number 2, I'm also finding that you violated the condition of curfew based on the evidence provided in exhibits A, C, G, H, and I. For charge number 3, I'm finding that you violated the condition of obedience to the law based on your conviction of criminal trespass third, when you were sentenced to 30 days in jail. And in addition, the evidence that supports the charge is exhibits A, C, F, and K. And for charge number 4, I also found that you violated the condition of drugs based on the evidence provided in support of the charge and states exhibits A, C, and F. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendations, the state will have an opportunity to speak to your background and history. And after the state's finished, you will have the same opportunity. The purpose of this part of the revocation hearing is to help determine what outcome I would recommend. So Officer Bartnick, would you like to make any comments towards Mr. Walker's background and history?
Not at this time, I do not.
Okay, thank you. So counsel, it is your opportunity.
Yes, on behalf of Mr. Walker, my client is 61 years old. My understanding, based on the documents, that this is his first violation. That's what I have. Hopefully, that's what you have also. Been out on parole since December 1st of 2022. As far as the arrest did not occur until March 3rd, 2025. So regardless of misconducts or not, he has not previously been remanded. He's been out since December 1st of 2022. My client does have 2 adult children, aged 29 and 25, who both live in Connecticut. On his previous release, he's reported to us he did successfully complete the Community Solutions halfway house in Waterbury, and then he was at the Connection Reentry Assisted the REACH program in Waterbury. He did have a case manager assigned to him, Mr. Ramos. He's also indicated to us he did, looks like April 27th of 2023 to March 31st, successfully complete the App Foundation Residential Inpatient Substance Abuse Treatment Program in New Haven. And then it looks like in April of 2024 to February 2025, he did self-sponsor in Waterbury. He was at that address until he was remanded. He did have a previous work history prior to his disability. Is currently fully disabled. He did have a work history as a tire technician, and he is on disability for medical purposes. He also previously had a full-time job at Nelson Heat Treating in Waterbury. He does, as I indicated, he is unfortunately disabled. He does suffer from congestive heart failure, diabetes, high blood pressure, and he has a hernia. He's been transported out of the facility at least 4 times because of his medical issues. And he does obviously need to, get treatment for his medical issues. He is amenable to being placed in a halfway house in the Waterbury, Connecticut. And at some point down the road, he'd like to secure an independent house like he previously had. And he's amenable to any treatment recommendations or conditions that need to be put on him. I believe he's currently receiving methadone and he is participating in NA meetings. So I am asking you to give him some consideration. I understand he does have some violations here. He's 61 years old, been out for a good stretch of time from December 1st of 2022. And this is his first violation. I understand the original arrest, what he was charged with on paper, but he did go through the court system. And at the end of the day, it was a 30-day sentence and a criminal trespass. The drug charges were not legal. Thank you.
Thank you. So I have listened to the testimony today and I've also reviewed the evidence provided. And I am acknowledging that you were out in the community for a long amount of time, Mr. Walker. It's a long amount of time to go backwards, right? So with that, I am going to recommend that your parole be revoked and that you serve an approximate 4-month period of confinement as a sanction. That's with the re-parole date of June 4th, 2025. With that, I'm going to recommend the following conditions: no contact with the victim, JS.
Man, can I speak something? Once, I really need to get out to get me a medical condition. I'm supposed to see a heart specialist last month in here. They haven't helped me not one bit. I have a congestive heart failure, and I really am trying to get to a halfway house, get back on the track and seeing these doctors. It's grateful that you're putting me back out, but I really need to get out there because they don't care about me. I've been going to the hospital through ambulance and stuff like that. I have a bad heart condition, and it's been a problem since 2001. You know what I'm saying? I'm very scared that something's bad gonna happen to me. I'm sleepwalking, going crazy up in here. The doctors will confirm that things are not working well for me. The psychiatrists and the doctors, they don't know what's making me sleepwalk and all this stuff, hurting myself, running into beds and stuff. I'm really having a rough time in here.
So, Mr. Walker, as I explained to you, this is a recommendation by the hearing examiner, okay? There's one more step. It has to go to the Board of Pardons and Parole. There's still a chance it might get lowered, but to be quite frank with you, what she's giving you, in my professional opinion, is in line with someone with a first-time violation and a criminal charge. I understand the more serious charges were not leading court, but they do have some guidelines and parameters they have to follow. So as I explained to you via telephone, if there's one more chance, you could get out earlier, but it has to go to the board first, okay?
Oh, I'm sorry.
That's okay. I understand, and she has a copy of your medical stuff we provided. I read some of it on the record, but unfortunately, this is the process, so you gotta.
I understand. I've never been through this before, and I'm really going through.
Okay. Just let her go through the dates here, and then we'll figure out what happens.
Yep. So the conditions, again, and I'm going to recommend as well, are the no contact with victim, JS, no operation of a motor vehicle without parole officer's permission, and halfway house placement. So as counsel had noted, there is a next step to this. So my recommendation is going to go to the board on April 17th. On that date, the board can do 3 things. They can lessen my recommended sanction if they want to do so. They can adopt my recommended sanction, or if they want to impose a sanction longer than what I have recommended, they will call a supplemental hearing where you'll be present for it to address their concerns of why they would want to further incarcerate you, okay? Any questions at this point for today's purposes?
Mr. Walker, that April 17th is a Thursday date. You will get something in writing. If you can get a phone call into our office on Friday, the 18th, one of the secretaries can tell you via telephone what the final outcome is. We don't have it in writing yet, but we'll be able to tell you. So if you call around 11, 12 o'clock on the 18th, one of my secretaries can give you the information over the telephone, and then the board will send you something in writing, okay? All right, good luck to you. If there's an issue with you getting out in June, or if that date changes, I'll set up a legal call with you. All right, good luck to you. Thank you, P.O. Bartnick.
For Sylvester Walker, inmate number 130938. Thank you, Officer Bartnick.
Thank you. Take care.
Hello?
Just gonna run out quickly and then we'll connect to Osborn and we'll do Mr. Gardner first, okay? Is that a
Oh,
few
you
more
want
there?
well, I was just curious if you wanted to do Alfonso, because he has two, and then I have the next slot.
I offered it to him, he said no.
Okay, perfect. Thank you. Thank you.
Thanks.
Bye-bye.
Good morning.
Hi, good morning.
How are you today?
I'm good. How are you?
I am great, thank you. Can we please start with Mr. Gardner?
Okay, and then who would you like after?
Let's do Gillard first.
Gardner, then Gillard, or Gillard first?
No, sorry, Gardner, then Gillard. And then
Okay, and then
Bennett. Yeah, that'd be
Okay.
perfect. Thank
Okay.
you.
You're welcome. Gardner?
Good morning, Mr. Gardner. How are you?
I'm good. How are you?
Good. So we have this hearing scheduled to start at 10:15. It's 10:10, so we have to wait about 5 minutes and then we'll get started, okay?
Yes, ma'am.
Okay, thanks.
No problem.
Good morning, Mr. Gardner.
Good morning, Mr. Ruff. Can I ask you a question, Rob?
Oh, I don't see why not.
I was wondering, because I had got a piece like paper in the mail, but out of the 3 charges, there was, remember that the last one that I didn't contact?
Right.
There was no finding on that, right? Like, because I left a voicemail and I contacted him when I had the police contact.
As long as there's a no finding, they can't consider that. But in fact, if they made a finding at the preliminary, I'll be making an argument that doesn't meet the preponderance standard. Okay. But either way, I wouldn't worry about that charge. Okay. Because you did contact. Okay.
Yes, sir.
Thank you, sir.
You guys ready to get started?
Yes, we are.
All right. So good morning, I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Mark Gardner, inmate number 374513. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Yes, ma'am. Mark Gardner, 374513.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Attorney Famiglietti, can you identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello.
Good morning. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can't be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Gardner, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. And then after considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, so we're going to go over the rights you have at today's hearing. The first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive that written notice?
Yes, ma'am.
Okay, great. So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am. I'm ready to go forward.
Okay, so we are now going to review the charges that the state or parole officer is bringing against you and the information underlying each charge. As you noted, so when I am reviewing the charges, I did make a note finding at the preliminary hearing on charge number 1, GPS part 3, dated 6/24/2024, and for the notification of arrest, which is charge number 3. And Parole and Community Services has not provided any additional information or evidence to support those charges, so they are not taken into consideration at today's hearing. So I'm going to omit them and skip over them as I'm reading the charges, okay?
Yes, ma'am.
All right, so for charge number 1, condition of GPS, I have that on 6/7/24, you're placed on GPS as an initial initial intake due to previous noncompliance in the community. At this time, you were instructed on and agreed to properly charging your GPS unit for 2 hours daily. On the following dates, you failed to properly charge your GPS unit as instructed, resulting in your GPS unit shutting down. On 6/10/24, your GPS unit shut down from 7:16 p.m. until 7:24 p.m., resulting in 8 minutes of your whereabouts in the community being unknown. On 6/14/24, you allowed your GPS unit to shut down from 3:54 p.m. until the next day at 6/15/24 at 1:45 p.m., resulting in a 21-hour and 51 minutes of your whereabouts in the community being unknown. On 6/26/24, you were allowed You allowed your GPS unit to shut down from 11:35 a.m. until 3:40 p.m., resulting in 4 hours and 35 minutes of your whereabouts in the community being unknown. On 7/5/24, you allowed your GPS unit to shut down from 6:53 p.m. until 9:19 p.m., resulting in 2 hours and 26 minutes of your whereabouts in the community being unknown. On 7/7/24, you allowed your GPS unit to shut down from 5:50 p.m. until 6:42 p.m., resulting in 52 minutes of your whereabouts in the community being unknown. On 7/16/24, you allowed your GPS unit to shut down from 6:13 p.m. until 9:55 p.m., resulting in 3 hours and 42 minutes of your whereabouts in the community being unknown. On 7/19/24, you allowed your GPS unit to shut down from 10:07 a.m. until 6:23 p.m., resulting in 8 hours and 37 minutes of your whereabouts in the community being unknown. On 7/20/24, you allowed your GPS unit to shut down from 8:32 a.m. until 8:54 a.m. and from 11:17 p.m. until the next day, 7/21/24 at 1:14 a.m., resulting in 2 hour and 23 minutes of your whereabouts in the community being unknown. On 8/4/24, you allowed your GPS unit to shut down from 11:35 a.m. until 12:31 p.m., resulting in 56 minutes of your whereabouts in the community being unknown. On 10/3/24, you allowed your GPS unit to shut down from 4:14 a.m. until 9:45 p.m., resulting in 17 hours and 31 minutes of your whereabouts in the community being unknown. On 10/19/24, you allowed your GPS unit to shut down from 6:40 a.m. until 6:47 a.m. and from 9:30 p.m. until 9:49 p.m., resulting in 26 minutes of your whereabouts in the community being unknown. On 10/23/24, you allowed your GPS unit to shut down from 1:40 p.m. until 5:36 p.m., resulting in 3 hours and 56 minutes of your whereabouts in the community being unknown. On 12/10/24, you allowed your GPS unit to shut down from 10:42 p.m. until 10:47 p.m., resulting in 5 minutes of your whereabouts in the community being unknown. On 12/17/24, you allowed your GPS unit to shut down from 1:37 a.m. until 8:33 a.m., resulting in 6 hours and 56 minutes of your whereabouts in the community being unknown. This results in an approximate 94 hours of unaccountability in the community with locations unknown to the parole officer. On all occasions above, your whereabouts in the community were unknown to the PO, which violates your signed GPS agreement. And then on charge number 2, condition of obedience to the law, the charging officer reported that on 12/21/24 at approximately 6 p.m., you were arrested by the City of Groton Police Department. On above date and time, you were seen exiting the parking lot off the roadway in and traveling well above the posted speed limit of 25 miles per hour. The roadway in is an area well known to law enforcement for narcotic trafficking and prostitution. At this time, a traffic stop was conducted. Before the arresting officer exited his cruiser, all 3 occupants in the vehicle, to include yourself, got out of the vehicle and began to walk away. You stated to the arresting officer that since you were already out of the vehicle, the officer was unable to pull you over. You were instructed to get back in the vehicle, but you refused to listen to verbal instructions and commands. During the stop, you continue to yell to responding officers, "You aren't searching my car." Your noncompliance with the officers continued throughout the entire stop. Due to your behavior, you were subsequently arrested and charged with 14-215, illegal operation of motor vehicle under suspension, 14-12A, failure to renew registration, 53A-167A, interfering with officers resisting, and 12-218A, traveling unreasonably fast. Ultimately, you were issued a misdemeanor summons, MB 823605, with a court date of 1/3/25 at GA 10. You were released on a promise to appear. The evidence submitted by the state was already identified at the preliminary hearing, and that all remains the same. The state then also did file an addendum to the parole violation report on 3/21/2025, and that's also admitted into evidence. And that states that on March 6, 25, Mr. Gardner was convicted of 14-215, illegal operation of a motor vehicle under suspension, and was sentenced to unconditional discharge. All of his other pending charges were not pursued. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the documents that have been identified for today's purposes?
Yes, we have.
I've also received an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate, counsel?
Yes, that is.
Do you need any time to submit any additional evidence?
No, we do not.
All right. So today we do not have the state present, so it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges of the evidence submitted.
As to the preponderance standard, I've got no comment regarding the unconditional discharge or the operating under suspension. All the others charges were not pursued, including the interfering. Our explanation for that charge is that he pulled into a parking lot. He didn't just pull over to the side. For safety purposes, he pulled into a parking lot. And he has this was just a motor vehicle stop. He has every right under the Fourth Amendment not to agree to a search of his car, particularly for a motor vehicle stop. There was a canine there, did a sniff. There was absolutely no contraband found whatsoever. He was cooperative, and he was actually trying to do the right thing. He pointed out to them that he had a bracelet, anklet, that he was on supervision. He was more than cooperative. So just as to the preponderance standard, I only think there's only a basis for the operating under suspension. Thank you.
Thank you. So I am going to announce my findings. For charge number 1, the condition of GPS, I am going to find that you did violate that condition based on the evidence supporting the charge and states exhibits B, C, E, G, and I. And for charge number 2, I also find that you violated the condition of obedience to the law based on your conviction of illegal operation of a motor vehicle under suspension when you were sentenced to unconditional discharge. And in addition, the evidence presented to support the charge is exhibits B, E, and F. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So counsel, would you like to make a statement?
Yes. So there was no finding as to charge 3 because he did that evening notify the police. I think that speaks to his responsibility and his acknowledgement of his duties while on parole. He also made the right decision to pull into the parking lot because he frankly didn't know why he was being pulled over. He admitted the operating under suspension. It's an extremely minor offense. And on top of that, he received an unconditional discharge. He had been on parole for 6 months prior to this. And if you look at the narrative in the parole violation report, somewhere down the line, it appears in December, and there had been many violations of the GPS. I'm only speaking to the 15 dates. His parole officer knew that my client was an over-the-road truck driver. His family owns a tow trucking business. He works there as an assistant. And it says this is in December, his officer provided Mr. Gardner with a car charger provided by PCS so he could charge his unit while working in the tow truck. My client wasn't violated after the 1st, 2nd, 3rd, 4th, even the 15th violation. It's only as a result of the operating under suspension, arrest, and eventual conviction was my client that was really the moving factor behind this remand. He's been held now since New Year's Eve, so he's been held over 3 months. The PO is recommending 3 months jail post disposition. He did not get any jail for the disposition. This is non-violent. This is a consequence, having tickets that resulted in his suspension. It's a consequence of his over-the-road job. It's just simply something that many people, whether they're on parole or not, do have tickets, and unfortunately, it's something that he could very easily rectify. This is his first violation. He notified his PO as well that day. My client, just going over some background. Pardon me, I'm going to find my report here somewhere. One moment. Oh, here it is. He's a 29-year-old man. He has support from his mother, father, 3 brothers, sister, and grandparents. Graduated from East Hartford High School. Part-time at Gardner's Auto Repair, which is his family business, began position there and worked until he was remanded. He did it immediately. He also worked seasonally part-time, which I think is admirable, at Rocks and Roots Tree Service for 2 months. He worked both positions simultaneously, looking for additional work as well. Completed anger management and Wheeler Clinic. He gets services from Windsor Family Medicine as he had a broken right hand. He volunteers at a healthcare organization in Hartford for 20 hours. Upon reinstatement, he'd like to be sponsored by Miss Green in Hartford. He would like to enroll in trade school and study heating, ventilation, and air conditioning, and he can return to the family business. I think this is a minor blip. It's his first violation. There's no reason to further incarcerate my client. He's learned his lesson. Certainly will have all of his paperwork in order in the future. Is a responsible young man, and I'd ask that you release him on that April date, please. Thank you for your time and consideration.
Thank you. So I have listened to today's testimony and I've reviewed all the evidence submitted. With that, Mr. Gardner, I am going to recommend your parole be revoked and you serve an approximate 4-month period of confinement. That's with a re-parole date of April 30th, 2025. With that, I'm going to recommend the following conditions: no alcoholic beverage consumption, behavioral management program for anger management, no operation of a motor vehicle without a parole officer's permission. I do see Ms. Green is your proposed sponsor. Who is she to you?
It's my girlfriend.
Girlfriend? Okay. So I will not do halfway house then at this point. There should be no issues with staying with her. They can figure it out if there is, okay? So those 3 conditions, again, April 30th is my recommended sanction. That recommendation is going to go to the board on April 17th. On that date, the board can do a few things. They can lessen it if they choose to do so. They can adopt that recommended sanction, or if they want to speak to you if they want to impose a sanction longer than what I've recommended. A supplemental hearing will be held. You'll be present for it to address their concerns and stuff, okay? So that does conclude today's hearing. Do you have any questions for me or your counsel?
No, ma'am. I appreciate both of you.
Thank you, sir. You can contact us on April 18th and we'll let you know what the final decision of the board was.
Okay.
It
Thank
was
you.
a pleasure representing you, sir. You have a nice day.
Thank you. Appreciate it.
This concludes the revocation hearing for Mark Gardner, ME number 374513. Thank you, Mr. Gardner. Good luck to you, okay?
All right. Love you too.
See you later.
All right. I will see you soon. Let's
Okay.
say soon.
All right.
Thank you.
Come on in, Gilliard.
Just had to grab your attorney, okay, Mr. Gilliard, and then we'll get started.
Okay, good morning.
Good morning.
Jason.
Good morning.
Good morning. I am Parole Officer Tricello. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jason Gilliard, inmate number 386079. Today is Monday, April 7th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Jason Gilliard, 386079.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your attorney, Attorney Sirica. Would you like to identify yourself for the record?
Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit, on behalf of Mr. Gillard.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Gilliard, can you please raise your right hand? You solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. Then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After the consideration of all the evidence presented, I'll announce my findings. And if I find you have violated one or more of the conditions to your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, so we're going to go over your rights right now. So the first right you have is that you have the right to an attorney, and counsel is here present for you. You also have the right to receive written notice of charges of violation. Did you receive the written notice?
Yes.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Thank you. So we're now going to review the charges that the state, your parole officer, is bringing against you and the underlying information of each charge. So in charge number 1, condition of GPS, the charging officer reported that on 6/22/24, you failed to properly charge your GPS unit, resulting in this device shutdown from 5:11 p.m. until 6/23/24 at 10:42 a.m. Approximately a total of 17.5 hours. For part number 2, on 6/23/24, you failed to properly charge your GPS unit, resulting in a shutdown from 3:22 p.m. until 4:05 p.m., total of 43 minutes. On 6/25/24, you failed to properly charge your GPS unit, resulting in a shutdown from 10:37 a.m. until 6/26/24 until 7:38 p.m., approximately a total of 33 hours. On 6/27/24, you failed to properly charge your GPS unit, resulting in a shutdown from 10:02 a.m. until 10:28 a.m., a total of 26 minutes. On 7/16/24, you failed to properly charge your GPS unit, resulting in a shutdown from 10:21 a.m. until 11:29 a.m., a total of 1 hour and 8 minutes. On 8/8/24, you failed to properly charge your GPS unit, resulting in a device shutdown from 5:18 a.m. You failed to charge your GPS device at any point after 8/8/24. Your above stated actions are in violation of your GPS agreement, which states that you will charge the device for 2 hours. For residents, it's charge number 2, residents. It states that on 6/21/24 and 6/22/4, you failed to reside in your only parole approved residence, Recovery 12 Solutions Sober House in Norwich. Charge number 3, condition of absconder, states that on 8/8/24, you voluntarily exited your only parole approved residence, Fellowship Halfway House, located at 466 Long Hill Road, Groton, and you did not return. All attempts to locate you were unsuccessful, and you have made no attempts to contact the halfway house or parole, indicating your intentions to purposely evade parole supervision. Your whereabouts in the community have remained unknown since 8/8/24. In charge number 4, condition of drugs, the officer stated that on or around 2/15/24, you used cocaine. And for charge number 5, condition of no consumption of alcoholic beverages, the charging officer reported that on or around you consumed alcohol. The state has filed the following exhibits that I have changes that have been marked for identification purposes as Exhibit A, the remand to actual custody. Exhibit B, the signed PCS conditions. Exhibit C, the notice of parole violation and parolee rights. Exhibit D, the parole violation report. Exhibit E, the halfway house agreement. Exhibit F, the GPS agreement. Exhibit G, the Premier Biotech Labs toxicology report, dash specimen collection date 12/20/23. Exhibit H, the Premier Biotech Labs toxicology report, dash specimen collection date 1/4/24. Exhibit I, the voluntary admission for alcohol use on 1/2/24. Exhibit J, the offender misconduct report dated 12/29/23. Exhibit K, the Premier Biotech Labs toxicology report, dash specimen collection date 2/15/24. Exhibit L, the offender misconduct report dated 2/20/24. Exhibit M, the Allied Universal Physician History 6/21/24 to 6/22/24. Exhibit N, the Allied Universal Event History 6/21/24 to 6/23/24. Exhibit O, the offender misconduct report dated 6/24/24. Exhibit P, the Allied Universal Event History 6/25/24 to 6/27/24. Exhibit Q, the offender misconduct report dated 6/29/24. Exhibit R, the Allied Universal event history for 7/16/24. Exhibit S, the offender misconduct report dated 7/16/24. Exhibit T, the Corrigan halfway house incident report dated 8/5/24. Exhibit U, the Corrigan halfway house disciplinary report dated 8/5/24. Exhibit V, the Allied Universal event history 24, and Exhibit W, the Fellowship halfway house incident report dated 8/8/24. In addition, the state has filed an addendum to the parole violation report on 3/3/2025, which is also admitted into evidence and states that the Board of Pardons and Paroles issued a warrant on 9/23/24 based on the report declaring the offender an absconder from parole supervision. On 2/28/25, Gilliard was located by Norwich PD and detained. That's pretty much it. He was served his notice and that was all uploaded. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
We did.
All right, and I also received as defense exhibits, or just one. I received exhibit 1, the list of parole accomplishments and future plans. Do you need any time to spend any other evidence?
No.
All right, so we do not have any witnesses at this time, so it is now a defense's opportunity to call any witnesses, present evidence, and speak to any other charges.
Yes, may I take these backwards real quick? What's charge number 5? There's no date or time listed on that regarding no consumption of alcohol, but it's on or around you consumed alcohol. I'm gonna ask that no finding be made on that. There's just not enough information there for me to formulate the defense on my client's behalf. So I'm asking that charge number 5 based on the violation details and no finding be made on that. So, Mr. Gillard, a couple questions regarding the GPS. There were some shutdowns, specifically June 22nd, 2024, June 23rd, June 25th, and June 27th of 2024. Could you let the hearing examiner, we're not disputing that you had some shutdowns. What was going on with your living situation at that time, and why were you not plugging in for the required 2 hours daily?
Okay, so I never had a key to my father's house. So there'd be times where I leave and he'd be gone, and I go back to the house and I can't get in the house and charge up. You know, so I'd be stuck out in the hallway waiting for him for hours, and it'll either die or I'll relocate somewhere else until he gets back, and then I'd be having to plug up at that time because he don't be at the house so much.
Okay, and that was for the June incidents, correct?
Yes.
Okay, then there was a change of address, but July 16th and August 8th, were you having some issues with your unit at that time?
Yes.
Okay, and who did you discuss that with?
Some of the staff there, because the pro officer wasn't there much. She just calls and tells them to plug up. So I'll be having to like run around, scramble around, and find somebody that got a charger that works that I can use.
Okay, do you recall, Jason, if the charger was swapped out at some point?
Yes.
And do you recall when that occurred?
When I was in the halfway house. I don't know exactly. It was either one of those dates, but it was when I was in the halfway house at in Waterbury.
But it wasn't the actual unit, just the charger was swapped out, correct?
Yeah, the charger. There was something wrong with the charger.
Okay. The allegation here, Jason, is you kind of off the grid. It looks like starting August 8th, and then you were picked up on February 28th. You did not encounter any. You didn't pick up any new charges. You didn't have any police contact until you were picked up on February 28th of 2025. Correct?
Correct.
Okay, and this is your first violation on your current supervision, and you've been out, looks like since December 11th of 2023?
Yes.
Okay, could you let the hearing examiner, what triggered you to go off the grid? What event in life occurred?
Okay, well, while in the halfway house, I have learned that I had possibly had a girl pregnant. It was, I had a kid on the way, possibly. I panicked. And also there was a lot of drug use in the environment that I was in. I really didn't want to be around. And I made a mistake by letting my emotions get the best of me dealing with a female. I wasn't thinking, and I had just left. I had nobody to turn to. I didn't know what to do. I couldn't talk to nobody in there because all my peers are most likely on drugs. I didn't know what to do.
And regarding that situation with the woman, a potential, my understanding, you're following up with that hopefully when you get back out regarding a paternity test, correct?
Correct. That's very important.
Okay. All right. I just want to give you a little background regarding what was going on. After speaking to Mr. Gillard, obviously there's a better way to handle. It seems to be a reoccurring theme where my clients are in halfway house. There's drugs and other things all around. I understand it's not the perfect setting for them. I guess it's better than being locked up, but I just want to give you a little idea. It's an individual, as I indicated, been out since December 11th of 2023, and this is his first violation, did not pick up any new charges. So anticipate you making some findings here, but I just wanted to paint a little bit of a background on Mr. Gillard's behalf. I do want to be heard about his background at the appropriate time. Thank you.
Okay, thank you. I'll just take a moment. I'll let you know my finding.
Can I please say something real fast?
Sure.
Okay. I mean, I wrote something, but I won't read it. But I'll just say one thing.
Hold on. We're gonna deal with the charges first. Jason, the background stuff, wait till the second part of the hearing. If you want to add, I'm gonna go over what you gave us, and then at the end, I'll give you an opportunity to, right now, she just focused on the charges. We're not to your background yet, okay?
Okay.
Okay, so for charge number 1, the condition of GPS was already identified as a 6-part. So I'm going to make a partial finding. On parts 1 through 5, I'm making a finding based on the evidence provided in exhibits B, D, F, N, P, and Q, R, and S. So for part 60 to 8A, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge. On charge number 2, the condition of residence, I'm also making a no finding. As I believe the state failed to submit sufficient evidence in support of that charge as well, and the elements were not met. On charge number 3, I do find that you violated the condition of absconder based on the evidence provided in exhibits B, D, and W. And also for charge number 4, I'm making a finding that you violated the condition of drugs based on exhibits B, D, K, and L. Lastly, I am making a no finding on charge number 5, condition of no consumption of alcohol. As counsel noted, there's no detailed information as to what the violation, what occurred. So those are my findings, and that does conclude the fact-finding portion of today's hearing. Before I do make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So counsel?
Yes, if I just explain to my client regarding your findings.
Yes.
So Jason, just before we talk about your background, the second part of the hearing, you heard her say you made a finding, no finding. So on charge number 1, it was broken down into 6 parts. Part number 6, on 8/8/24 days, she made a no finding. So that particular date will not be used against you, okay? Charge number 3, under residence, she made a no finding on that violation, so that's not being used against you. And charge number 5, no consumption of alcoholic beverages. There was a no finding on that, so that will not be used against you. Do you understand that?
I understand. Thank you.
Okay. All right. So regarding Mr. Gillard, as I indicated, this is my client's first violation. He's been out on supervision since December 11th of 2023, as my paperwork indicates. As I indicated, I understand you made a finding on the absconder charge. My clients did not pick up any new charges while he was out for a bit. Under radar, and then he was picked up, but no new charges. He's 32 years old. Upon his previous release, he was sponsored by his father. Then he was at the Recovery Solution Sober House in Norwich. Then he was sponsored by his mother. So he's had numerous sponsors in the community without issues in the past. He did receive his high school diploma from an alternative school through Norwich Public Schools. And he also did enroll in an online cybersecurity program. He was supposed to start, and then he was remanded. He did have employment while he was out, had a full-time job at Holiday Inn in Norwich for a couple of months. Then he worked full-time at Ruby Tuesdays for a couple of months. And then prior to him transferring to the Chase Center, he was hired at AC Linen in Norwich and Chipotle restaurant. And then he was transferred to Waterbury. Obviously, he didn't begin those jobs. And most recently, he did have a job of the landscaping company and painting company through one of his friends. He also reported to us he participated in outpatient services, including individual psychotherapy and medication management, Waterstone Counseling in London, and also participated in the Evolve program. He's also reported to us he did successfully complete domestic violence program while previously incarcerated. He did get a job in the facility, working in the kitchen, 4 a.m. to 12 p.m., which is the first shift. On his reinstatement, he's amenable to place at halfway house in Norwich is his first choice, followed by New Haven or Middletown. As I did indicate on the record regarding what happened, he is following up on the paternity test regarding situation with the potential child. And as I said, he does have a job lined up in the landscape field with one of his friends, and he's amenable to any treatment recommendation that he needs to do as a condition of his parole. Jason, anything you want to add about your background? You can't talk about the charges. That part has already been dealt with. But anything you want to add about your background or what you want? This is your opportunity now.
Just really, I apologize. That's about it. That's all I gotta say. I mean, I was wrong. I could have just been patient and just waited it out, but I left. But it's really different leaving an environment like this to a halfway house versus being home in the community and that feeling of moving backwards. You know what I mean? And I would like to utilize all the resources that halfway houses and parole has to offer before my end of sentence, so I can, properly reintegrate into my community the right way.
Thank you.
Thank you.
And I am with his final comments. I understand there's a date that's not that far out. I am asking you to consider my client back out. He's been in since February 28th. My humble opinion, without a new date is kind of for someone's first violation. And I am asking you to consider letting him back out. As in his own words before he beat me to it, he does want to utilize some of the services. Just to end date and to throw him back out without anything lined up is going to be difficult for Mr. Gillard after me speaking to him. I am asking you to consider giving him some opportunity back in the community before he finishes the supervision. Thank you.
Yeah. Take a moment. Okay, so I have listened to today's testimony. I've also reviewed all the evidence that has been submitted. With that, Mr. Gilliard, I am recommending your parole be revoked and that you serve an approximate 3-month sanction as a period of confinement, and that's with a referral date of May 28th, 2025. With that, I'm recommending the following conditions: no alcoholic beverage consumption, behavioral management program for domestic violence and anger management, no contact with victim JD, and a general no contact with CR, also halfway house placement in Norwich, correct?
Anywhere available, really.
Norwich, is that Norwich your first choice? She has to kind of put them in chronological order. I believe that's what you gave us. That's what I put on the record.
Yeah.
Sure, yes.
Okay.
All right, and halfway house placement. So that is my recommendation. It's going to go to the board on April 17th, 2025. On that date, the board can do a few things. They can lessen my recommended sanction. They can adopt it, or if they choose to do a sanction, impose a sanction longer than what I've recommended, there will be a supplemental hearing that you'll be present for to address their concerns before they issue that sanction, whatever they choose to do. Okay. Any questions?
So yes, so I'm giving a date of May
28th is your re-parole date. Just hold on, Jason. We got to clarify some things. You have them as discretionary parole.
I do have discretionary.
So you are on discretionary parole. So it's on or after date. They do not have to, so we're all clear. May 28th or after is your re-parole date, with the understanding, Jason, it still has to go to the Board of Pardons and Parole, like I explained to you. On April 17th, they have the final say, but whether you get out on May 28th or thereafter, they can hold you longer, they can hold you until October if they choose to. I'm hoping they adopt the recommendation, okay? To make it really simple, I know you're gonna wanna know, if you give our office a call the next day, which is Friday, April 18th, that's not Good Friday, is it?
It is.
It is, huh?
And we've been telling
Yeah, no.
everyone.
Give us a call. Unfortunately, I keep telling my clients, call the office April 18th, I believe is Good Friday. Give us a call on Monday. We can give you the information over the telephone. One of my secretaries can, if the board adopted the recommendation or yeah, rather than having you wait to get it in writing. So give us a call on Monday and we can tell you over the phone, okay?
All right, thank you.
All right, good luck to you.
This concludes the revocation hearing for Jason Gilliard, inmate number 386079. Thank you, Mr.
All right,
Gilliard.
good luck, Jason.
You're good, thanks.
Take it with you, go ahead. And just sit there in front of you, you can sit in the chair. Go ahead, keep going. No, just take the chair in the front. Yep, that's it.
I'm gonna do this.
Yep, sit down.
Look, listen, you know what? I don't understand a lot of English.
Okay, he doesn't understand too much English. Have a seat.
We have an interpreter.
Yeah.
Thank you.
Good morning, Officer Bennett. Are you with us?
Hi, how are you?
Good morning. Okay, so I am Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. I'm gonna actually swear in our interpreter now because she's gonna assist us in today's hearing. So Ms. Rivera, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that you will faithfully discharge according to law your duties as an interpreter to the best of your ability, so help you God upon penalty of perjury? I do. Thank you. So I am Officer Trisella. I'm hearing examiner for the Board of Pardons and Paroles, and this is a preliminary hearing concerning Norberto Millet, inmate number 062230. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New Haven, Osborn Correctional Institution.
Buenos días, soy la oficial Truselo, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia preliminar en referencia a Norberto Millet, número 062230. Hoy es lunes 7 de abril del 2025 y esta audiencia está siendo conducida vía video en la oficina central de la Junta de Indultos y Libertad Condicional y el centro y la institución correccional de Osborn.
This is a public hearing and public access to this hearing is available via video live stream. Can you please just state your full name and DOC and number for the record?
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. Si por favor nos puede decir su nombre y número de confinado de DOC para el registro.
And present this morning is Attorney Sirica, and he has requested to speak to his client.
Can you have him put his name in?
Si puede decir su nombre y número de confinado para el registro.
622 Harry, and my name is Norberto Millet.
And I'm attorney Alfonzo Sirica, public defender with the Parole Revocation Unit on behalf of Mr. Millet this morning.
Está el abogado Alfonso Sirica de la Unidad de Revocación de Libertad Condicional representando al señor Millet esta mañana.
Okay, so Norberto, I attempted to speak to you on April 3rd, last week of 2025. Do you recall my telephone conversation with you?
Señor Millet, ¿usted recuerda la conversación telefónica que tuve con usted el 3 de abril?
And there was some difficulty with you understanding the English language, correct?
Yeah.
Había cierta dificultad usted al entenderme a mí.
Okay, so for today's purposes, what I attempted to tell you, you have a case pending in court. I'm not sure if you're aware, but you have a court date on April 14th of 2025 in Bridgeport Superior Court. Are you aware of that date?
Yeah, I remember that. Yeah, I went there.
Can you just please?
Well, Mr. Millet, you have to let our interpreter interpret for you since you requested her to be here, okay?
Le queríamos mencionar que usted tiene un caso pendiente en corte con la Corte Superior de Bridgeport el 14 de abril del 2025.
So what I'm going to advise you to do today, Norberto, I'm going to advise you to waive this preliminary hearing today with the Board of Pardons and Parole, because we can't have your revocation hearing until the case is resolved in court. So I need for you to take care of the case in court first, okay?
Lo que queríamos decirle es que yo le aconsejaría que en el día de hoy usted renuncie a esta audiencia de libertad condicional, ya que usted tiene un caso pendiente en corte y usted no puede tener una audiencia de revocación hasta que todavía no se resuelva el caso pendiente que tiene.
Do you understand that?
Yeah, but I don't remember what kind of case I have.
It's three. You're going to go to court on April 14th. There's 3 charges. The attorney in court will go over that with you. I don't represent you in court, but you have a court date of April 14th, okay?
April
Usted
14th.
Usted tiene 3 casos pendientes, 3 cargos pendientes que usted todavía tiene que presentarse en corte el 14 de abril.
Once that case is resolved, I will set up another call with you with a Spanish interpreter, and I will advise you as to what's going to happen with the Board of Pardons and Parole for the revocation hearing, okay?
Después que este caso se resuelva en corte, yo voy a hacerle una llamada telefónica a usted con un intérprete para entonces hablar acerca de lo que va a suceder en su audiencia con la Junta de Libertad Condicional.
Do you understand that?
Sí, pero lo que no entiendo es cuáles son los casos que yo tengo, 3 casos.
It's
No
not 3
sabes.
cases, it's 3 charges.
No son 3 casos, son 3 cargos.
And the
Uh-huh.
lawyer will go over that with you on April 14th.
El abogado va a hablar sobre esto con usted el 14 de abril.
Okay?
Okay.
So based on my client, I am waiving the preliminary hearing today with the understanding he has the case pending in court. Probable cause has been established by Superior Court. Once that case is resolved, we will schedule him for his revocation hearing with the understanding the outcome in court will play a role if there's going to be a revocation hearing or not. Because I see July 16th as the EOS day here.
Okay. All right, so I am gonna accept counsel's waiver on the record, conceding to probable cause. With that, I'm also finding the acts are serious enough to warrant the revocation. You will be detained while you await your revocation hearing, which will take place after your case is disposed of in court.
Lo que va a suceder en el día de hoy es que vamos a renunciar a su audiencia preliminar, ya que tiene pendiente su caso en corte el 14 de abril. Y después de esto, entonces vamos a ver qué va a pasar en relación a su audiencia de revocación. Por lo tanto, se acepta esta renuncia en el registro, ya que un juez de la Corte Superior identificó causa probable.
And can we just clarify? Norberto, I represent you for the parole violation. So I have one part of your case. The case in court, you're going to have a different lawyer. So I don't represent you in the Bridgeport court. That's why I can't answer those questions for you.
Lo que quería explicarle a usted es que hay dos etapas aquí. En la parte en que yo le represento a usted es en la violación a libertad condicional. El 14 de abril, en su caso de corte, usted va a tener un abogado diferente que lo va a representar en cuanto a esto. Por eso es que yo no le puedo contestar estas preguntas.
And once he resolves the case in court, I will reach out to him regarding his parole violation.
Tan pronto este caso se resuelve en la corte, yo me voy a comunicar con usted en referencia al cargo de violación de libertad condicional.
Okay.
Sorry, I didn't even check. Officer Bennett, are you with us right now?
I am, yep.
Sorry, so you heard all of that? Everything's good?
Yep.
Okay.
Yep,
All
we're
right.
good to-
So then this does conclude the preliminary hearing for Norberto Millet, inmate number 062230.
Norberto, I'll talk to you after you resolve your case in court.
Esto concluye la audiencia preliminar de Norberto Millet, número 062230. Señor Millet, yo me voy a comunicar con usted tan pronto el caso de corte se resuelva.
Okay.
Okay?
Thank you.
Thank you.
Good luck, Mr. Millet. Thank you, Officer Bennett.
Thank you, guys.
Millet.
You go? I
Yes.
go?
Yep, you're all set. Thank you.
Have a good day.
Thank you.
Thank you.
Hey, Trish.
Hi.
Hey, I just sent you an email. Do you have a copy of the docket I could have? I can't find it in my email, just so I can follow along.
I will try to find it.
It's not, it's fine. No worries.
There's one right before you at 11:15, and then yours is at 11:45.
Beautiful. And I just
Yeah.
wanted to ask you real quick, like normally, sorry, I'm looking at the wrong screen. Normally when it's a criminal charge, they normally waive the prelim, no?
It depends. They don't have
Oh, it
to.
depends. It does?
Yeah.
Okay. All right,
Yeah,
cool.
they
All
don't.
right, thank you.
No problem.
Okay.
Officer Trusello, I do have the docket saved if you want me to send that.
If you don't mind, Miss Benedict, you're the
Because I have
best.
it. I have it ready.
Thank you so much. Thank you.
Good morning.
Good morning. Can you hear me?
Yeah, gotcha. We
Okay.
just have one with you, Audet, right?
Yes, I'm gonna call him down now. It disappeared from our screen, so we wasn't sure if it was still continuing or not.
Boy, okay, yep, we're gonna go forward. That'd be great.
Okay, we'll call him down right now. Give us a couple minutes.
Yep, thank you. Good morning, Mr. Audet.
Good morning, ma'am.
Morning. All right, we're gonna get started. Good morning. I am Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Shawn Audet, admit number 286027. Today is Monday, April 7th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
Shawn Audet, 286027.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, everyone.
Good morning. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that, more probably than not, the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Audet, can you please raise your right hand? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for your hearing today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present on today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
I do not.
All right, so you do have important rights for today's hearing. The first is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
I did, ma'am.
Great. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
I do, and I am.
Okay, so we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So for charge number 1, condition of curfew, the charging officer reported that on 5/5/24, you were not your parole-approved residence at the time of your 9 p.m. curfew. You were not given permission to be up past 9 p.m. You did not return to your residence until 1:30 a.m. on 5/6/24. On charge number 2, condition of obedience to the law, the charging officer reported that on 5/1/24 at 19:38 hours, police met with the victim of an assault at Day Kimball Hospital. The victim stated that you were inside the vehicle when the assailant, and then you exited the vehicle when the assailant began to physically hit the victim with a pipe. The assailant hit the victim 10 times in the arms, forearms, elbows, hands, back, and head, causing multiple injuries. A witness reported that they attempted to run outside to break up the fight when you physically blocked the witness from going to help the victim. 2 witnesses stated that you were a participant in the assault by blocking and keeping the witness away from the victim so that the assault could continue. On 6/26/24, CT State Police submitted an arrest warrant affidavit for the charges of 1 count breach of peace and 1 count conspiracy to assault second. On 7/24/24, the warrant was signed by Judge Green at GA 11. Charge number 3, condition of no consumption of alcoholic beverages. The charging officer reported that on 5/6/24, you provided a urine specimen that tested positive for alcohol. You verbally admitted that you used alcohol within the past few days. The specimen was sent to Premier Biotech Labs, LLC. A final report was received from the lab on 5/9/24, which confirmed positive for alcohol. The state has filed the following exhibits that have been remarked for identification purposes as states Exhibit A, the signed statement of understanding and agreement, conditions of parole. Exhibit B, the remand to custody order. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, the CT State Police arrest warrant affidavit 2400171953. Exhibit F, the Premier Biotech Lab report. Exhibit G, the Allied Universal GPS monitoring report. Exhibit H, misconduct. Exhibit I, the previous parole violation summaries. Exhibit J, the parole decision information summary. And Exhibit K, the GPS monitoring agreement. I do have a note here, though, that I did not receive Exhibit J, the parole decision information summary, so that is not admitted into evidence nor taken into consideration at today's proceedings. In addition, the state filed an addendum to the parole violation report on March 7, 2025, and that is admitted into evidence and reads as follows. On 3/5/25, the offender was sentenced on docket W11D CR 24-0191-521S to 1 count reckless endangerment first, 7 months jail. The original charges of count 1 conspiracy to assault second and count 2 breach of peace second was substituted for the current reckless endangerment first degree charge for which the offender was sentenced. Please schedule a parole revocation hearing based on the disposition of the charges. Additionally, if the offender is re-paroled, the following recommended additional conditions should be added: no contact with co-defendant Ruben Fields, no contact with victim SC, and a general no contact with MM Senior and BV. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Okay. And then I also received an exhibit from the defense. I have Exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Counsel, do you need any additional time to submit other evidence?
No, we do not.
All right, so we do not have any witnesses today. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges of the evidence submitted. Counsel?
Yes, I've got no comment as to the one use of alcohol in the 4.5-hour past curfew. As to charge 2, the charges were substituted and not pursued those other allegations. There's no allegations that my client assaulted anyone ever or intended to assault anyone. And the only thing that he did admit to was being reckless, not intentionally causing the crime, but being reckless, and he received a sentence of 7 months, which he has served. I have no other comment as to the preponderance standard.
Thank you. All right. So I'm now going to announce my findings. On charge number 1, the condition of curfew, I do find that you violated the condition based on states exhibits A, D, G, H, and K. And for charge number 2, I'm also finding that you violated the condition of obedience to the law based on your conviction of reckless endangerment first on March 5th, 2025, when you were sentenced to 7 months in jail. In addition, the evidence that supports the charge was exhibit A, D, and E. And on charge number 3, I'm also finding that you violated the condition of no consumption of alcoholic beverages based on the evidence provided in support of the charge in states exhibit A, D, and so that does conclude the fact-finding portion of today's hearing. Before I make my final recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So, counsel, would you like to make a statement?
Yes. So my client is 46 years of age. He's been involved in the criminal justice system since he was very, very young. This is allegedly his 5th violation. However, and the PO is recommending up to a year. I think that's excessive in this set of circumstances. We have him out on parole for approximately 5-6 months when this occurs. He only has, and we're only talking about 5 days of conduct in that whole time. On 5/5, he's briefly past curfew, 1 violation. And on 5/6, he used alcohol, but he admits it. All else that we're really addressing here is the underlying incident. He served about 9 months. He's been in jail about 9 months for that. And it is hard to imagine what could have happened. We're assuming what could have happened. A lot of things could have happened. He's alleged to have held someone back from entering into a fight. He didn't start the fight. There was no conspiracy to start the fight. He was not acting with this person. Worse things could have happened if a third party got into that fight. That third party could have gotten hurt. He had no idea what the intention of this person running into this fight was, who or what their interests were, what their motives were. So he essentially kept someone out of a fight. We don't know. We can't assume what that person would have done. There's no evidence what that person would have done, whether they would have been further injured, whether the victim would have been further injured. As a result, probably, of my client's record, he received a 7-month sentence. He's done that 7-month sentence. He's had no graduated interventions or sanctions during it up and until this time. He was in the Explore program, or has begun the Explore program, and he'd like to finish that. He's a 46-year-old male. He receives support from his mother, his eldest son. He has 3 sons, ages 27, 18, and 6. Unfortunately, his 6-year-old has been diagnosed with autism, and my client is working towards getting custody of that youngest son full-time. He went to work, took care of his kids, and did his best. He had a full-time position. He's an excellent employee. He worked full-time as an iron worker at Iron Fist Erectors in Killingly. He was employed the entire time he was in the community. He received passes to go to work on Cape Cod. He was trusted to leave the state to do his job. He has been working full-time as an iron worker and also at All Brothers Construction on a Plainfield, being employed at the time of remand. He has an excellent work history. In March 11th of 2024, he participated in the Explore program. He did 17 of 26 sessions at the time of remand, which I think is admirable. While he was on Cape Cod, with permission and didn't stray at all, he attended 12-step meetings. He's been in MAT, successfully completed a month at the App Foundation Residential Services Division. He's waiting again to participate and finish those Explore classes. While incarcerated, he was trusted enough to work as a restrictive housing unit worker. He would work 12 to 16-hour shifts. His primary responsibilities were to organize and cleaning the unit, preparing bedrolls for inmates entering restricted housing, and to keep lists of items that needed to be stocked. He wishes to be placed with his mother, when, again, where he was successful in the past, he can return to Iron Fist Erectors. I don't want the violent nature of the assailant, of the other party, and there's been no proof that there's any relation between these parties. I don't want the violent nature of this assault to be imposed in a sanction on my client. He did receive a stiff sentence of 7 months. He's completed that stiff sentence. And for all other descriptions of what's going on in this man's life, he's doing very, very well. He's working hard. And so one can make the argument that he was trying to de-escalate the situation, not escalate it. They're assuming he's trying to escalate. He's de-escalating by stopping someone from entering a fight. So we'd ask that he be released sometime in April. He has served about 9 months at this point in time. We're asking for a 7 to 9 month sanction. Thank you for your time and consideration.
Thank you. It's going to take a moment, then I'll announce my recommendation.
Sir, did you want to say anything or no?
Can I add something, please? Some of this, some of this might repeat what Mr. Famiglietti said. I just want to say, first off, I just wanted to thank you for the opportunity this morning. I know you guys are definitely probably tired of seeing me. I just want to explain that, again, as he said, upon my release last time, I didn't enter back into society and do the same things I've done in the past. I worked my butt off to change my actions, my behaviors, and still continue to today. I know that I have to be held accountable for what transpired that day. I didn't go there with Mr. Field to cause harm to anyone. I was asked to help him get his motorcycle and clothes, and had I known his intentions, I would not have went with him. Through my trials and tribulations with addiction, I still feel like a certain duty to like people from my past and present. And I try to be there for the people that are struggling. Like I have 2 friends that I would still text every morning on my way to work at 5 o'clock in the morning, telling them don't give up, that people care about you. You know, you don't have to use today. And even Ms. Esposito used to tell me I need to worry about myself. I understand that, but I also know how important a text like that could be to somebody who's struggling that wants to give up that day. That was the reason I was just trying to be there for certain old friends. While I was home, I was compliant with parole, as Mr. Famiglietti said. I attended all the groups while I was there, the 17 out of the 26. I embraced the opportunity to learn from past mistakes and acquire new skills that will help me going in the future. I never missed a day of work. I worked hard every single day. I even walked into parole. Like in the past, I used to dread going to parole. This time I didn't. I walked into parole confident because I knew I was clean. I knew I was living right. I knew I was doing the right thing. And I would just like an opportunity to resume that. On the weekends, I would come home on Friday from the Cape and pick my youngest up. And that was the highlight of my weekend. It's just seeing his joy, pure joy of him with his father. And as he stated, I was working, trying to get him full time. I will continue to work even harder moving forward to be a good man and a good father. So I just humbly ask that you consider giving me one more opportunity to which I can go back and resume my life and being a productive member of society and being the best father and man I could possibly be. Thank you.
Thank you. I do appreciate your statement. I am just gonna, like I said, take a moment and then I'll let you know my recommendation. So I have listened to today's testimony, and I really do appreciate your statement, Mr. Audet. However, this is your 5th violation, and I do know that council's arguing your part in the violence of it, but you got to make better choices. And it is still a situation. You do have to worry about yourself. It sounds like Officer Esposito kind of gave you that advice because you're what's important for you. So with that, I am recommending, and Parole and Community Services has asked for a 1-year sanction. So I am going to recommend the same, a 1-year period of confinement as a sanction. That's with the re-parole date of July 29, 2025. In addition, I'm recommending the following conditions: no alcoholic beverage consumption, behavioral management program for anger management and domestic violence, no contact with co-defendants, EW and RF, no contact with victim KA without parole officer's permission, a general no contact with NS, TC, SC, MM, and BV. And we're gonna go with the sponsor you said, right, your mom? So we don't need a halfway house. So those are my recommendations. They are gonna go to the parole board on April 17th, 2025. On that date, the parole board can do a few things. They can lessen my recommended sanction. They can adopt it and let it stand. Or if they choose to impose a sanction longer than what I have recommended, there'll be a supplemental hearing held. You'll be present for it. You'll be notified of it to address their concerns and any questions that they have. So this does conclude your revocation hearing. Not sure if you have any questions, counsel.
Just briefly, sir, the board is going to meet on the 17th. They have the final decision.
Correct.
So on the 18th of April, please call our office and
Sorry, we
you.
realized that the 18th of April is Good Friday.
Oh, okay.
I know it took a long time.
It's okay. The following Monday, call our office and we'll let you know what the board decided. Okay.
Okay. Thank you.
All right. Good luck, sir. I wish you the best.
Revocation hearing for Shawn Audet. Go ahead. I'm sorry.
And I hope that you reunite with your son full time. Okay, sir.
Thank you very much.
And keep up the good work. Keep up your sobriety.
Absolutely.
Okay?
Absolutely.
Take care.
Thank you.
This concludes the revocation hearing for Shawn Audet and make number 286-027. All right, Mr. Audet, you're all set. Good luck to you.
Thank you. Have a great day.
Care. Thank you, Attorney Famiglietti.
Thank you, hearing examiner Trusello.
You have a great day.
You too.
Officer DeJohn, I will connect with York shortly, but we'll start at exactly 11:45.
Thank you, ma'am.
Thank you.
Thank you.
Morning, Miss Fitzgerald, right?
Yes, hi.
Hi, so it is 11:42. We cannot start until exactly 11:45, so we'll get going in 3 minutes, okay?
Okay.
Oh, I just turned off my recorder instead of on. Sorry, 1 second. Good morning. Is it morning still? Yeah. Good morning. I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Amanda Fitzgerald, MA number 373325. Today is Monday, April 7th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New York Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Hi, good morning. My name is Amanda Fitzgerald. My main number is 373325.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Dean and Parole Officer DeJohn. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean for the record on behalf of Ms. Fitzgerald. Good morning, everyone.
And Officer DeJohn, can you please identify yourself for the record? You're muted. Yeah.
Sorry, Parole Officer DeJohn. I'm a parole officer in the women's unit here at Hartford. Hi, Amanda. Good morning, everybody.
Morning. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on close supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Ms. Fitzgerald and Officer DeJohn, can you please raise your right hands? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Thank you. So we're gonna go over the procedure for today's hearing. So first, I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have the opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights for today's hearing, and I'm going to review them with you now. The first is you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you also have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we're now going to review the charges that the state, your parole officer, is bringing against you, and the information underlying each charge. So Officer DeJohn, can you please read the charges that you have brought against Ms. Fitzgerald?
Yes, ma'am. Charge number 1 is release direction, program participation. You were instructed to participate in the Moving On program and were unsuccessfully discharged on 2/6/25 due to you failing to participate in the program. On 8/1/24, after testing positive for cocaine and fentanyl, you were instructed to attend intensive outpatient treatment and to provide documentation of this to your parole officer. You failed to provide documentation as instructed. Obey all laws. Charge number 2, obedience to the law. On 3/6/25, you were found by New Britain Police to be loitering in the area of Columbus Boulevard in New Britain, Connecticut. You admitted to smoking crack cocaine out of a pipe, and you admitted to throwing the pipe in an attempt to destroy the evidence. You were also found to be in possession of 3 full and 3 broken glass pipes with crack cocaine residue on them. Due to your actions and behaviors, you were charged with the following crimes: tampering with evidence, interfering with an officer, possession of drug paraphernalia, possession of a controlled substance, and a city ordinance violation, loitering. Charge number 3, drugs. On 8/1/24, you rendered a toxicology screen that tested positive for cocaine and fentanyl. You voluntarily admitted to having used said illegal substances. On 8/16/24, you rendered a positive toxicology screen for cocaine and fentanyl. You signed a voluntary admission form admitting to doing a line of cocaine and smoking a blunt. On 8/24/24, you rendered a toxicology screen that tested positive for cocaine. You denied any illegal drug use. However, the Redwood toxicology results report indicated you were in fact positive for cocaine use. On 9/6/24, you rendered a toxicology screen that tested positive for cocaine, fentanyl, and THC. You voluntarily admitted to having used cocaine. On 3/6, you admitted to New Britain Police that you were smoking crack cocaine out of a pipe, and you admitted to throwing the pipe in an attempt to destroy the evidence. You were also found to be in possession of 3 full and 3 broken glass pipes with crack cocaine residue on them. This is a direct violation of your parole conditions. Charge number 4, halfway house placement. On 9/3/24, you received a work pass from 3:30 p.m. until 12:00 a.m. You did not report to work as scheduled. You signed out of the halfway house at 11:27 a.m. and did not return until 9/4/24 at 2:50 a.m., leaving you unaccountable in the community for approximately 15 hours. This is a violation of the written rules of the halfway house. On 9/6/24, you left the halfway house on a work pass. You did not report to work as scheduled. You were unaccountable, and your whereabouts in the community were entirely unknown during this period of time. This is a direct violation of the written rules of the halfway house. On 12/4/24, you admitted to staff at Silliman Halfway House you engaged in a sexual relationship with another offender admitted to the program. This is a violation of the written rules of the halfway house.
Thank you. You also submitted evidence. Can you please identify the exhibits that you have submitted?
Yes, ma'am. Exhibit A, Connecticut Conditions of Parole. Exhibit B, Notice of Parole Violation. Exhibit C, Parole Violation Report. Exhibit D, Remand to Actual Custody Order. Exhibit E, New Britain Police Department Report. Exhibit F, Email from CPA regarding moving on unsuccessful discharge. Exhibit G, Signed Offender Misconducts. Exhibit H, Signed Offender Voluntary Admissions. Exhibit I, Toxicology Results. Exhibit J, Silliman Halfway House Time Card Documentation from 9/6/24. Exhibit K, Residential Services Manual for Silliman Halfway House.
Thank you. I do want to note on the record that I also received Community Solution Incident Reports, and I'm going to identify those as Exhibit L. Counsel, did you and your client receive the notice of parole violation, the parole violation reports, and all the other documents that have been identified?
We have, great.
I did receive a document from the defense. Do you want this to be listed as an exhibit?
Yes, please.
All right, so I have exhibit 1 from the defense, which is the criminal/motor vehicle conviction case detail for Ms. Fitzgerald for her docket number ending in 608S. So I will admit that as exhibit 1 of the defense. Counsel, do you need time to submit any additional evidence?
No, we do not.
Okay, so we do not have any witnesses today. So at this time, it is the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer DeJohn.
I just have a short thing written up. Ms. Fitzgerald has continued to display criminogenic behavior patterns during this period of her parole. Since May of 24, Ms. Fitzgerald has rendered 3 toxicology screens that tested positive for cocaine, fentanyl, or both. Most recently, she was found to be under the influence of illegal substances, having drug paraphernalia on her, which then led to her eventual arrest. She was offered the opportunity to participate in IOP treatment and then placed in the App Foundation without having completed IOP. She was placed on GPS twice. All of these efforts were made to help Ms. Fitzgerald in her rehabilitation, and she continued to use illegal substances, causing her to reoffend in the community. This is why I recommend Ms. Fitzgerald parole term be revoked and she stay incarcerated until July of 25.
Thank you. Counsel?
Yes, thank you very much. As to charge 1 program participation, regarding the piece that had to do with the AIC moving on program in Hartford, I would just note that I spoke with my client, and those alleged absences I do not think were intentional, but were due to my client experiencing transportation issues. I believe she was residing out in the Unionville area, which is approximately 30 minutes or so, give or take, of a drive from Hartford, depending on traffic. And I believe that at the time she was also struggling with transportation, which made it difficult for her to get to the sessions there. As to charge 2 obedience to the law, I did submit the exhibit that indicates she took a plea for 1 count of possession on 3/6/25, and she just received an unconditional discharge, no time to serve, no additional supervision. As to charge 3 drugs, my client notes that she never admitted to using substances to the police on that 3/6 date. And I will also note that she was not found with any drugs on her person per the police report in Exhibit B. She indicates that the pipes were not used for crack cocaine. They were marijuana pipes, but were not used for illicit substances. And I also will just note that the residue that was allegedly found on those pieces of evidence were never tested per the police report. So it is not confirmed what was on or used for those specific pipes. And then finally, the last charge, halfway house placement. As to the allegation on 12-4 regarding the relationship, I spoke with my client at length about this, and she indicates that this is not accurate, and she never had an intimate relationship with the other client in this program. She indicates that they were good friends, but this never surpassed the level of friendship. And in fact, actually a staff member, I believe, from that halfway house did pursue a romantic relationship with the same individual, and they are, I believe, under investigation regarding that incident. I would just argue that this is not a situation where the violations or the proposed violations are serious enough to warrant future incarceration for my client. She got no time to serve in court for the criminal conviction and no additional supervision. So they clearly did not find that this conduct was serious enough to warrant her being incarcerated. I would also argue that as to that charge 2 obedience of the law, an addendum was not submitted within the 14th day of the charges being adjudicated pursuant to section 54-124A sub J 1-7 of the regulations. In fact, 21 days at this point have passed since the disposition in criminal court. So I would ask you to take that into account. This is her first violation. Her parole is up in August 9th to be exact. So I would argue that having her released from the community so she could establish services within the next few months to get the assistance of parole in order to get back on her feet would be very beneficial to her. But overall, I would just argue that this is not serious enough to warrant revocation. Thank you very much.
Thank you. Any further comments before I do announce my findings?
Am I allowed to speak?
Yes, Amanda, if you would like to speak, you certainly can. I will caution you, though, I wouldn't say anything regarding the criminal case or the charges themselves. But if you have something additional that you want to say, that's fine to put it on the record at this point.
I just wanted to say, I was doing good, you know, with my CCAR recovery coach academy. Even here, my teacher for CCAR, is encouraging me to want to get back in the community to become a recovery coach and wants me to be assistant for a recovery coach. With reentry, Robin Ledbetter, I'm still engaging with her. So, I mean, you know, I kind of like need the assistance with Parole.
Thank you.
Thank you. I do appreciate your statement. I'm still gonna just take one moment and I'll let you know my findings.
Can I say something else or no?
Absolutely.
I just wanted to say in regards to the drug charges, you had said that it wasn't a pipe for crack cocaine smoking, but they did take those substances back to the lab in the police report and they tested them and it tested positive for crack cocaine.
The pipes did?
Yep, it says on page 3, it says they were transported to New Britain PD. The officer held a field test on the suspected crack cocaine and showed preemptive results for cocaine. The crack cocaine was found to have an aggravated weight of 3.2 grams.
But that is, those are the alleged drugs that were seized from my client's co-defendant. My argument was that the alleged things that were seized from her, the actual pipes themselves, the pipes were not tested. But the drugs that were found on the co-defendant certainly were. That's not in dispute.
Okay.
So for charge number 1, the condition of program participation. I'm actually making a no finding of probable cause based on the information reviewed for this preliminary hearing, as I feel that the state has failed to submit sufficient evidence in support of the charge and the elements were not met. On charge number 2, condition of obedience to the law, I am making a finding. I'm going to use exhibit 1 from the defense, as Ms. Fitzgerald was convicted and sentenced to unconditional discharge on 3/7/25 for possession of controlled substance. In addition, the state submitted the following evidence that supports the charge: exhibit A, C, and D. For charge number 3, the condition of drugs, I identified this as 5 separate parts. So for part 1, I'm making a partial finding. So for charge number 5, part 1 dated 8/1/24 and part 3 dated 8/24/24 and part 4 dated 9/6/24. And lastly, part 5 dated 3/6/25. I'm making a finding of probable cause based on state's exhibits A, C, G, H, I, and L. For part 2 dated 8/16/2024, I'm making a no finding of probable cause. Again, as I feel the state failed to submit sufficient evidence in support of the charge. Same thing for halfway house. I have identified this charge as 4 separate parts. So for part 1 dated 9/3/2024, I'm making a finding of probable cause based on state's exhibits A, C, G, and J. For part 2 dated 9/6/24 and part 3 dated 12/4/2024, I'm making a no finding of probable cause based on the information reviewed for this hearing today, as I feel that the elements were not met based on the evidence submitted. So with that, although I am making findings, I'm also making the determination that the acts are serious enough to warrant revocation. So I am making the finding of the facts and that they are serious, but I'm also finding that you can be released back. No, I did the wrong one. I am sorry. I am all over the place. I need 1 second. Sorry, and counsel, you mentioned that she's done with parole in August?
Yes, 8/6/25 is her max date.
She's on.
Or sorry, 8/9/25. Yes.
Okay, so I am finding that the acts are serious enough, and I'm also finding that they're serious enough to warrant revocation. So with that, I've determined that you should be detained while you await your revocation hearing. So the records office at the facility will be notified of that, and the parole officer is now notified of that. So we will try to get your revocation scheduled sooner than later, since those charges were disposed, but we do need information from the field. I'm not sure how that works with them not submitting it within the 14 I'll go over it with Ruth at this point. And then we will try to schedule that revocation hearing, like I said, sooner rather than later.
All right, so Amanda, it should be approximately, I will submit that information today and ask for the addendum to be submitted. So hopefully within 30 to 60 days, we'll get scheduled, okay? And I'll set up another call with you and my social worker will be reaching out to you before the secondary hearing, okay?
Okay, yeah, thank you.
Thank you so much.
Have a good day.
Preliminary hearing for Amanda Fitzgerald, inmate number 373352. Thank you, everybody.
Thank you.
Have a good day.
Thank you.
Hello?
Hi.
Hi. I just want to apologize about that. We were having technical issues with our screen.
No way, don't even know because we were a little bit late. You're perfect.
Thank you so much. He's
Thank
right here.
you.
You're welcome.
Thank you. Mr. Price, right? You're Mr. Price, correct?
Yes.
Okay, great. All right, let's get started. So I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Maxwell Price, inmate number 358150. Today is Monday, April 7, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Carl Robinson Correctional Institution. Can you please say your full name and DOC inmate number for the record?
Maxwell Price, 358150.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Dean. Attorney Dean, can you please identify yourself for the record?
Yes, Hannah Dean on behalf of Maxwell Price. Good morning, sir.
Good morning.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding and anything you say at this hearing can be used against you. This hearing is also being recorded. Counsel, do you want me to sign your swear your client in?
No, we don't intend to ask for testimony today.
Okay, so this hearing is being recorded. So we're going to go over your rights, the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state your parole officer is bringing against you. I'll then review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at today's hearing, and we're going to review them now. The first is you have the right to an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive the written notice?
No.
Did you get the paperwork from Parole that had all
Oh,
of the
yes,
information?
yes.
Yeah.
Okay, all right,
Yes, I'm
perfect.
sorry.
That's fine, as long as you received it. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights? Now you're ready to go forward.
Yes.
Okay, so we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So on charge number 1, condition of residence, the charging officer reported that on 2/26/2025 at approximately 7:10 a.m. you were not located in your assigned room during house check. You left Isaiah halfway house without permission. You left your parole approved resident. Sorry, I am just making up words. You left your parole approved address without program completion or permission and became unaccountable in the community. Your whereabouts were unknown until you were located by this officer on 3/18/2025, 20 days thereafter. You violated your special parole condition number 1, release direction. The state has filed the following exhibits that have been pre-marked for identification purposes, which is Exhibit A, the remand to actual custody order, Exhibit B, the parole violation report, Exhibit C, the notice of parole violation, Exhibit D, the notice of parolee rights, Exhibit E, the signed PCS special parole conditions, Exhibit F, the signed halfway house agreement, Exhibit G, the Isaiah House incident report, and Exhibit H, the East Hartford signed arrest warrant / police report. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified?
Yes, we have.
Great. I have not received any evidence or exhibits from the defense. Is that correct?
Yes.
Do you need any time to submit evidence at this point?
No.
Okay. So we don't have any witnesses, so it is the defense's opportunity to respond or make a short statement, calling witnesses and testify with respect to probable cause and severity of the allegation.
Yes, thank you very much. I don't have any specific comments as to the charge. However, I do just want to note a few things for the record at this point. As indicated in the narrative section of the PVR, my client does currently have a case pending out of GA12 with the next court date of 5/9 for allegations that supposedly or allegedly occurred in July of 2024. Nevertheless, I do just want to note that despite Pia Rory clearly knowing about this, and including it in the narrative, and then also including that warrant as Exhibit H. Unfortunately, that violation was not included, or that conduct was not included as violation ground. However, Parole clearly knows about these allegations that are underlying this situation and have made it clear that they are not including that as a charge here. I would argue that proceeding on a violation in this fashion is inappropriate and is an abuse of the parole revocation process to effectively plan potentially a future violation for my client when the allegations underlying that violation are available and known to parole and the hearing examiner at this time. So I did just want to make a record of that. Certainly we will see what happens in court and go from there. But I did just want to note that at this point, that since that information has been submitted as an exhibit and then also included in the narrative, that I'm hoping going forward it can be considered. Thank you very much.
Thank you. I'll take a moment. I'll announce my findings. Okay, so for charge number 1, the condition of residence, I am making a finding of probable cause based on state's exhibits B, E, and G. With that, I am also finding that the acts are serious enough to warrant revocation. And I've determined that you should be detained while you wait for the revocation hearing. So the records office at the facility, as well as your parole officer, will be notified. Again, I will try to get that hearing scheduled sooner than later. Just so you're aware, the revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, the hearing examiner will then make a recommendation regarding whether your parole should be revoked and if a sanction should be imposed. So that does conclude today's preliminary hearing. I, again, am going to attempt to try to get it scheduled.
Just for a quick question, since the criminal conduct was not part of the actual charges, does that case have to resolve before he can be scheduled, or will he be scheduled prior?
So my understanding is that his hearing will be scheduled within 60 business days.
Okay.
Of it. So we'll try to get it scheduled. See what happens.
Okay, thank you very much.
Right. So this does conclude the preliminary hearing. We are going off the record, okay?
All right, Mr. Price, I will schedule another call with you. I'm going to call up your attorney who you have in the criminal court to discuss this with them as well, okay?
Okay, thank you.
All right, thank you very much. I'll talk to you soon.
All right, have a good one.
Thank you too.
Here. Oh, this concludes the preliminary hearing for Maxwell Price. I mean, number 358150.